Good morning, everyone, and welcome to the 16th meeting of this committee in 2020. Before moving to the evidence-taking session, can I invite Andy Whiteman, MSP, who will be substituting for Alison Johnson, MSP, to declare any relevant interests.
I have no relevant interest to declare. Convener.
Thank you very much. Our public business is an evidence session on the complaints handling phase of our inquiry. I wish to highlight the position the committee is in today in relation to the written evidence to inform this session. Around 300 documents were received yesterday afternoon, and given the complexity of the legal restrictions on the committee's work, parliamentary officials now require to process these documents before publication. We also anticipate around a further 100 documents from the government, and the timescale for this is to be confirmed. These documents also require to be processed before publication. The Deputy First Minister's letter on this matter highlighted that witnesses attending today are not in a position to answer on any matter which is not in these documents, where contempt of court is a consideration. On that basis, the committee is asking questions today in the absence of written evidence that the government considers witnesses can answer questions upon. I speak for the committee when I say this is not a satisfactory way to proceed in effective scrutiny, but we will persevere in the interests of progressing the task the Parliament has tasked this committee to fulfil. I appreciate this situation is not of the witnesses' making, and I'm sure they will endeavour to answer the questions as far as they are able. And can I ask Jackie Bailey to make her contribution at this point?
Thank you very much, Convener. I think we should put on record that it was actually at 4:45 last night that the Scottish Government provided the documents to this committee. By anybody's reckoning, that is the 11th hour and 59th minute. The letter from John Swinney asking us not to reference certain information is extremely difficult for the committee on the basis that we do not have the written evidence in front of us, and therefore it makes it difficult to ensure that the committee is sticking to the strictures placed on us. We know, though, that that information was returned to the Scottish Government by Levy and McRae some weeks ago. So it is beyond disappointing that it is only now being provided to the committee. I think this committee needs to reserve the right to recall the witnesses that we have before us today when we have seen these documents, and can I express my anger at the continuing obstruction of the committee's work by the Scottish Government. It is clear to me that this is part of a wider pattern of behaviour, and it disrespects both the committee and the Parliament. Thank you, Convener.
Thank you, Ms Bailey, and all of this will of course be discussed further with the committee in private session. Today's meeting will be held in two parts, with part one this morning and the second this afternoon, commencing at 3:30 p.m. I don't intend to repeat my statement from the start of our meeting on 18th August, but I would remind all those present and watching that we are bound by the terms of our remit and the relevant court orders, including the need to avoid contempt of court by identifying certain individuals, including through jigsaw identification. We are not here to talk about the substance of the complaints, but about the complaints handling process. And we all recognise the impact that public discussion of these issues can have on those who have experienced sexual harassment. The committee as a whole has also agreed that it is not our role to revisit events that were a focus of the trial that could be seen to constitute a rerun of the criminal trial. Our remit is to consider and report on the actions of the First Minister, Scottish Government officials and special advisers in dealing with complaints about Alex Salmond, former First Minister, considered under the Scottish Government's handling of harassment complaints involving current or former ministers, and procedure and actions in relation to the Scottish Ministerial Code. The more we get into specifics of evidence like time, people, cases, the more we run the risk of identifying those who made complaints. The more we ask about specific matters covered in the trial, including events explored in the trial, the more we run the risk of rerunning that trial. In questions, reference to specific dates and individuals should be avoided, and questions should be phrased in general terms where possible, to avoid the risk of jigsaw identification or complainants. I would also emphasise that the committee would be content to receive written supplementary points should any witness have concerns that their response may stray into this territory. Wherever possible, can witnesses, as well as members, also avoid naming specific government officials under senior civil service level? With that, may I welcome Judith McKinnon, Head of People Advice at the Scottish Government. The committee has agreed that while members can see Ms McKinnon, her evidence will be broadcast in audio only. And I begin by inviting Ms McKinnon to take the oath. Ms McKinnon, would you please raise your right hand and repeat after me? I swear by Almighty God
I swear by Almighty God
that I will tell the truth, the whole truth, and nothing but the truth.
that I will tell the truth, the whole truth, and nothing but the truth.
Thank you, Ms McKinnon. May I invite you to make an opening statement, please?
Thank you, Convener. My opening statement aims to set out my role and responsibilities as the investigating officer into the harassment complaints raised against former First Minister. As explained at my previous attendance before committee, I am a CIPD qualified HR professional with considerable experience in carrying out and advising on workplace investigations and instructing employment tribunals. I've been the Head of People Advice since August 2017 when I joined the Scottish Government. In response to the Permanent Secretary's staff message at the beginning of November 2017, which was intended to raise awareness and tackle the issue of sexual harassment at work, a number of channels were put in place to enable people to come forward. A number of people did come forward over the following months to share their experience of harassment in the workplace, some about civil servants and some about the former minister. Took a person-centred approach with the aim of understanding the experience and respecting the wishes of those individuals, including access to a formal process where required in line with our duty of care. 2 people decided they wanted to make formal complaints under the harassment procedure about a former minister in January 2018, and again in line with our duty of care, a formal investigation commenced. As the appointed IO, I was responsible for undertaking an impartial collection of facts from complainers and from witnesses that arose from the complainers' accounts and those identified by the former First Minister. Provided regular update information to complainers on the progress of the investigation and produced interim and final reports for the Permanent Secretary to consider in her decision-making capacity. As has been set out previously, I'm giving evidence to the committee on behalf of ministers and not in a personal capacity. The committee will be aware that there is an undertaking given to the Court of Session which applies to my investigation reports and other documents created or given to me during my investigation. I must comply with that undertaking, as to breach it could constitute contempt of court. There is also a disagreement between the Scottish Government and Mr Salmon's legal representatives regarding the decision report. I am advised that while that disagreement remains, there may be certain questions about the decision report which I cannot answer. Do so may amount to contempt of court. If I am concerned that I may breach the undertaking or risk at any point identifying the complainers, then I will have to decline to answer at this time and come back to you in writing so that the impact of the contempt of court order can be considered fully. I will also do that to ensure accuracy on detailed matters. And finally, Convener, I remain a member of the FDA Trade Union.
Thank you very much, Ms McKinnon, and we'll go straight to questions from our committee members. First of all, Margaret Mitchell.
Thank you, Convener. Good morning, Ms McKinnon. Under our first theme, the process and support to raise a concern, can you explain how the Scottish Government could accept an indication of an individual wishing to make a formal complaint in mid-December for a policy which was not agreed until 20th of December?
Sorry, can I just clarify your question?
how you could accept an indication from an individual that they wanted to make a formal complaint and that to be indicated in mid-December and accepted for a policy that wasn't agreed until the 20th of December.
It's true to say that one of the complainers indicated, I think on the 19th of December, that she would likely make a formal complaint, but that she still had some questions that she wanted clarified. And at that point, you're correct that the policy was not signed off. The policy was signed off the following day, the 20th of December, and I had provided the complainer with a response to her queries that she had submitted on the 19th of December.
And
So at that point, she still might not have actually made a formal complaint. It was an indication only.
And you provided that additional information when?
On the 19th of December.
Right, so that was all considered. Can I ask therefore whether the individual wishing to move to the complaints phase was told to wait until January 2018 to make formal complaints so that it or any other complainant could be dealt with under the procedure?
I think what we said to her was, or I said to her, was that we would speak again in January. So at that point, it was still an indication, and it was for her to decide finally what she wanted to do, which she did in January.
You appreciate this all appears rather convenient. Perhaps if I could move on to your last appearance before the committee, and you confirmed then that you had contacted Police Scotland to seek advice on handling cases of sexual harassment, and that several officers had come to meet with you in December 2017. I asked you who you had contacted, and you wrote to the committee following your appearance to confirm that Gillian Russell had provided you with a contact in the Public Protection Specialist Crime Unit. In your written evidence, you describe this December 2017 meeting as a generic meeting about person-centred approach, a person-centred approach that did not include reference to any specific concerns, complaints or individuals. So can you expand a bit more about that meeting? For example, who else was present at this meeting?
So there was myself from Scottish Government, and I think there were 3 officers from Police Scotland in the meeting. And we were...
Carry on? Yeah. And no one else was present?
Sorry. No.
No, thank you. And how did the information you received from the police inform HR's approach and that of the informal confidant?
Very much from that person-centred perspective, though it was about being open to someone who comes forward, not to be judgmental, to be able to listen to them, to understand their concerns, to understand why they had come forward, to start to understand what they would like to do, if anything, and very much be kind of directed by the individual, very person-centred approach.
Okay, and I think you indicated before with the generic meeting that if we wanted to know who was there from Police Scotland, we'd have to contact them directly. Was that correct? You're not able to say?
Yes.
Okay.
No.
Moving on now, during the course of the investigation, were you involved in discussions on the referral to the police?
So at the end of July 2018, after I had submitted the final IO report to the Permanent Secretary, who was the decision maker, I was asked to sound out how the complainers felt about the Scottish Government potentially reporting the matter to the police. So I did that, and I spoke to both complainers, and they had some questions, mainly about what the next steps would be, what a police process might entail, what would be expected of them, etc. So I contacted one of those officers who had met previously, and again, it wasn't case specific, but I was asking her to help me be able to feed back to those individuals about what they could expect as part of a police process.
Right. And you're not able to say who that police officer was, are you?
No.
No. Okay. And can you give an approximate date such discussions took place, and were any other senior officers or officials involved when you had these soundings and you talked to the complainants in the way you've described?
No, it was just myself. I had a telephone call with one of them, and I met with one of them, and then we had some follow-up email correspondence.
Right, and the referral wasn't considered till a little bit later then. Should it have been considered at the point the concern was raised?
Do you mean the initial formal complaint coming in?
Yeah.
At that stage?
Yeah.
I'm not aware that it was considered. I think that we were very much in the fact-finding stage of the situation. And I don't remember an actual conversation once the complaints came in about reporting at that stage to the police.
Okay, but it was part of the route map, wasn't it? An option was to report to the police.
Yes, I believe so.
So that must have formed part of the thinking and discussions as the process was developed, and certainly when the complaints were received and the investigation took place.
I think that once the fact gathering had been done and the full picture was known, I think at that stage, and that was when the Permanent Secretary is the deciding officer to consider the appropriateness of referring it to the police.
Okay, thank you.
I have a supplementary on this issue from Maureen Watt.
Thank you, Convener. Good morning, Ms McKinnon. You said that the Scottish Government reported the matter to the police. Do you think that's appropriate? Don't you think as an employer you should have said to your employee, oh, you must go to the police and report it yourselves? A third party reporting a matter to the police seems a bit odd.
The procedure allows for both, actually. So, and very clearly set out in the procedure that individuals at any time could go to the police if they wanted to. And similarly, it states that the Scottish Government may, at some point, decide that a referral was appropriate. So the procedure allows for both of those things.
Don't you think that it looks pretty bad, as if the Scottish Government are kind of encouraging the complainant to go to the police rather than them making up their own mind?
Well, as I said, the decision for Scottish Government to make in relation to that was clearly set out, and one of the reasons for myself speaking to the complainers to test out their views about potentially reporting it to the police was for their views to be taken into account as part of that consideration. I have to say, I wasn't, just shortly after I started those conversations with the complainers, I handed over to Nikki Richards a continuation of that discussion because I went on leave and I was overseas. So I started the conversation, and I think my understanding is that that continued, and their concerns were responded to after I went on leave.
Okay, thank you, Convener. I'm sure others will pick it up.
Yeah, I have a question before I move on to Murdo Fraser on the same issue. Can I ask Ms McKinnon, you used the expression that you were asked to sound out the complainers about reporting to the police. Who was it that asked you to sound them out?
That would more than likely be Nikki Richards.
Okay, thank you. Murdo Fraser.
Thank you. Thank you, Convener. Good morning. Ms McKinnon, just to follow up on this line of questioning from other colleagues, would it be fair to say the complainants were reluctant themselves to report to the police?
I think you could say that. I don't think it had been their intention when they initially had come forward to do that.
So would it be fair to say the matter would not have gone to the police had yourself and the Scottish Government not taken it to the police? The complainants would not have done that off their own bat?
I can't say that for sure.
Okay. Okay, thank you.
Alistair Allen.
Thank you, Convener. Ms McKinnon, as you're more than aware, in the end the case was conceded around issues around perceived bias and the involvement at multiple stages of the same individuals. To your knowledge, did anyone raise concerns about the fact that you had already been involved in creating the procedure and you were now going to be investigating officer and implementing that procedure?
No. I think I responded to this in my previous attendance at committee. I think those of us who were involved had aware and knowledge about my prior contact, which was limited and administrative. Those involved also had the same approach and interpretation of paragraph 10, which was that the IO would not be involved in the matters being complained of. And so that awareness from the outset that I had had that prior contact was not raised as an issue at any point during the process.
Thank you. And how many people were involved in appointing you to that role of investigating officer? I'm not asking you to name people who are not senior civil servant level, but who appointed you to that role?
So Nikki Richards, who was my line manager and the director of people, appointed me to the IO role.
And I think this may have been a question I've asked you or others in the past, but even putting to one side the whole content of the policies that we're talking about, very important as those are, in terms of common sense, did it occur to you at any stage that this was an odd situation to be involved at multiple stages of the process?
Not from a standard HR perspective, no. It felt relatively straightforward.
Okay, thank you, Convener.
Yes. When you became the investigating officer, were you consulted at all by anyone from the Scottish Government Legal Directorate to make sure, or did you consult anybody from the Legal Directorate to make sure that there wasn't any reason why you shouldn't take on this role, given its importance and the potential legal repercussions if the appointment wasn't in line with the requirements? No, I don't recall a specific discussion around the appropriateness of my appointment. As I said, those of us who were involved were very aware of our interpretation of the procedure, the policy statement, and the awareness of my prior contact. Nobody raised a concern about that, and they knew about it. Everyone knew about it before I was appointed as the IO. So when did the concern about that it wasn't a particularly good idea and that may cause problems, when did that become apparent and who did it become apparent to?
To my understanding, it became apparent during October 2018 as part of the judicial review process. And I think my understanding is that it was Scottish Government's counsel who hadn't been aware of the prior contact who had raised it.
And before that, there was no hint from anybody that they thought that it wasn't the brightest of ideas?
No.
Okay, thank you.
Alex Cole-Hamilton.
Thank you very much, Convener. I have one small supplemental to Margaret Mitchell's line of questioning and then move into some more detailed issues of my own. Margaret Mitchell asked you, good morning, Judith McKinnon. Ms McKinnon, Margaret Mitchell asked you about the timeline of the first disclosure from the complainers to the introduction of the policy on the 20th of December. Can I just ask, had the complainer insisted on making a formal complaint in early November when this first came to light, how would that have been handled in the absence of a policy covering former ministers?
If someone raises a complaint, we have a duty of care to investigate it. And whether we have a policy in place or not, then we are obligated to investigate it. It would have made life quite difficult not to have a procedure in place, but we would still have been obligated to do so.
Okay, and was there any suggestion at the time when this person or persons came forward that they hold back, saying there is a policy coming that will suit your complaint, can you just hang fire?
No.
Okay.
Not as far as I know, certainly not from myself.
Okay, just move into a different line of questioning here. Just going back to November 2017, there was a lot going on. There was the Me Too movement, there was the Mark MacDonald resignation. We also understand now, or through the deliberations of the committee, that at that time, senior members of the government were being made aware about allegations made against Alex Salmond in Edinburgh Airport. Can I just ask, in terms of background and what was going on while this policy was developed and those complainers were starting to come forward, when you first learned of the particular allegations against Mr Salmond from the airport?
I didn't know and still don't know what the particular allegations against Mr Salmond were about the airport.
I'm sorry, I'll rephrase, not the detail, but when did you first learn there were allegations coming from the airport, irrespective of whether you were cited on the detail?
So my involvement was limited to staff welfare rather than what was being raised. So my understanding was that the former First Minister and or his lawyers had been contacting Scottish Government staff, and they had raised that with their line managers. And I was asked to contact the lawyers and just simply ask if they wished to speak to any Scottish Government staff, if they could direct that through myself.
And can you give us an approximate?
And that was all.
Can you give us an approximate date for that? Is it early November,
early
late November? So, I'm sorry,
early November.
Early November. Okay, thank you. Going back to early November, can you remind us how it was that first meeting that you had with Miss A? How did that come about? I mean, did she approach you? Was it through an intermediary, or did you understand that she had something to say and sought her out?
So my first awareness of Miss E was on the 22nd of November. And my understanding was that she had met with Gillian Russell and Barbara Allison. And in Gillian's role as this confidential sounding board. And after that meeting, Gillian notified myself and Nikki Richards of the meeting, in the name of the individual anonymous. And we agreed that she would suggest to the person that she could have a conversation with someone from HR if she wished to. And Gillian did that, and then we, I think the individual got in touch with Nikki directly, and Nikki we set up a meeting for the 5th of December, and that was the first time that I had met the individual. So that was my understanding of the sequence of events to my first meeting, the individual.
So can you just confirm, you said the 5th of December, our papers suggest it was earlier in November that that meeting took place and is referred to in document XX047 in the first week of November 2017 that is when Nicola Richards and yourself first met Miss A.
No, it was December.
Okay, that might just
December
be
2017,
that
definitely.
might just be an error in our papers. Thank you for that. So when did you first become aware that you would likely become the investigating officer?
So Nikki and I had been having discussions in early December about that, and I think, as I'd said previously, that there was felt to be 4 conditions required for an appropriate investigating officer. They had to be senior enough, have some experience in looking into matters like this. Had to be someone who was unconnected to any of the individuals who might be raising issues, and have no involvement in the matters that were being complained of. We were trying to keep the number of individuals limited who were involved, and also there had to be an ability to make the time to be able to carry out the investigation. So on that basis, Nikki had suggested that I would be, it would be myself, most likely that would be the IO.
So it was contemporaneous with that first meeting in early December, around that time, early December 2017.
Yeah, early December, yeah.
So on the 6th of December 2017, you received an email from Nicola Richards, which is referenced in document in our papers XX047, in which Nicola Richards specifically asked you to look at the timeline, and there's a range of sort of events that took place around that month of November and early December, and suggested it might need, quote unquote, testing back against the policy. Can I just ask what you understood that to mean?
I don't have that document in front of me, and I think I would like to refer to it before I respond, if you don't mind.
Okay, I mean, I can just read you. It's not a long email. I will read you the email. It just said, "Hi there, I've updated the timeline, and this is the final version of the policy I've sent to PermSec. Do you want to have a look at the timeline and see what you think? It might need testing back against the policy."
I can't recall off the top of my head. Sorry,
okay.
I'll have to get back to you on that point.
That's absolutely fine. I've just a couple more questions, Convener, if I may. This is fast forwarding to when Mr. Salmond was first told about the government investigation. And the Permanent Secretary wrote to Mr. Salmond on the 7th of March 2018. In that letter, it invited him to suggest witnesses to be contacted and his version of events to be set out. And you were appointed, as I understand, the sort of recipient or the intermediary to whom he should correspond. Did he make any such recommendations or contact you with a list of questions or concerns?
The Levy and McCree, the lawyers, got in touch with me directly about witnesses and to provide details of witnesses for me to contact. and I had correspondence back and forward with them around those witnesses and the provision of written statements.
And when you received that correspondence, what was the process by which you would decide what would be shared with Mr. Salmond and what would not be? I mean, who would you discuss that with?
Shared in terms of what? Sorry.
Well, you were the intermediary. You were receiving the correspondence from Levy McRae, and obviously this was a bit of a bombshell moment for Mr. Salmond. This is suddenly a revelation that he's under investigation by the government he used to lead. There would have been quite, I would imagine, a range of suggestions or concerns or protestations. How would you handle that? Any correspondence you received from Levy McRae, would you take a decision yourself? Would you take it to the Permanent Secretary? Would you take it to Nicola Richards?
So I think it's important to distinguish what my interaction with Levy McRae was. It was very much limited to the provision of witnesses, names and statements. The broader correspondence, I think that you're maybe referring to around Levy McRae's responses to the Permanent Secretary's letter were really for between the Permanent Secretary and Levy and McRae. So the kind of back and forward and the protestations, as you say, you know, the disagreement with the approach that was being taken, that was actually all between the Permanent Secretary and Levy and McRae. I had really quite a limited role in terms of getting from them the names of people that I could contact and then interview and engage with.
Thank you for clarifying that. So in respect of the requests or the recommendations of witnesses that Mr. Salmond would like the government to interview, did you act on all of those recommendations? Did you seek out all of those witnesses as described by him?
Yes, I interviewed, we put forward 5 people, I think. And I interviewed 3 of them face-to-face. I had 1 telephone consult with 1 of them, and a 5th person provided a statement via the lawyers, and that was taken and incorporated into the report.
Okay, thank you. Final question for me, Convener, if I may. So within the Senior Civil Service or the SNP, who else knew about the complaints and the investigation, either from the start of November till the sort of public revelation of their existence in the summer? Was it a big group? Was it a small group? Can you name them?
No, I think it was, well, we certainly tried to keep it as tight as possible. And in the very early days, it was really limited to those individuals who have already been named as being involved. So, you know, people like Nikki and myself and Gillian Russell and Barbara Allison, SGLD. So that was kept really tight as the investigation commenced. Once the Permanent Secretary had got in touch with Mr. Salmond's lawyers, and there were obviously then ongoing actions that were taking place. Again, I think it was that small group who were involved. Yeah, I think the kind of wider group was later after the decision came out and the judicial review process began. There was a kind of a wider group of people who were involved.
And to your knowledge,
included things like, sorry.
That's okay. And to your knowledge, was anybody in the high command of the SNP or in the special advisor role functions, as in chief of staff or other special advisors within the SNP, aware of the existence of the complaints or the investigations against Mr. Salmond prior to the turn of the year? So in the November-December period, when they were first forthcoming, were any of the people who are not necessarily career civil service, but either special advisors or SNP staff themselves, aware in any way of these complaints?
Not as far as I am aware.
Okay, thank you.
Angela Constance.
Thank you very much, Convener. I've got a couple of follow-ups and then some questions of my own. Good morning, Ms McKinnon. Ms McKinnon, you said earlier to Margaret Mitchell and others that you knew that it was possible that individuals that you were sharing the draft procedure with, in your own words you said, were likely to make a complaint. Therefore, do you now think, with hindsight, that it was inappropriate to show them draft copies of the procedure?
I think it would have been more ideal if the procedure had been finalised, but we were clear with it was only shared with one complainer, and we were clear with her that it was still in a draft state at that point, but it was nearing its final version.
Okay. And you also said previously, Ms McKinnon, that you thought that your contact with complainers was clearly allowed under previous drafts of the procedure. Can you confirm that you accept that for the purposes of the complaints and for the judicial review, that the only iteration that other people saw and the only interaction that actually matters is the final draft of the procedure, as opposed to previous iterations?
I absolutely accept that the removal of the more detail of the previous versions of the procedure left paragraph 10 open to other interpretations. Absolutely.
I suppose what my question was, Ms McKinnon, is that actually at the end of the day, the only draft that matters is the final draft, the draft that was approved, and that perhaps earlier iterations and what that meant or didn't mean in many regards is irrelevant.
I don't disagree with you. All I would say is that all employment policies, HR policies, are open to interpretation of how they are applied. When we go to employment tribunals as a matter of course to defend a position of dismissal or, whatever, these arguments with people who bring complaints and the Scottish Government centre around the application of policy and procedure in most cases and the different interpretation of those things. So it's not uncommon for us as an organisation to be able to have to defend our position in relation to an interpretation of a policy.
Okay, I'll move on to some other aspects, Convener. Ms McKinnon, am I correct in understanding that your role was to gather and present information from the complainants, but your role was also to prepare and present information gathered from Mr Salmond? You had...
Yes, correct.
Okay. Again, I appreciate hindsight's a wonderful thing, but would you now consider that a conflict of interest?
Not quite sure I understand what you mean in relation to the two different sets of witnesses. Is that what you mean?
Yeah, I just think it's quite a simple question with respect, Ms McKinnon. You had the dual role, if I can put it that way, where you had to, in an unbiased manner, collect information from those who were making complaints and present that information to the ultimate decision maker, but you were also charged with preparing and gathering information from the individual who the complaints were about.
So I would say that that is common practice for an investigating officer to investigate all parties concerned about a complaint. And the role of the IO is then to prepare a report which has all of the information in it no conclusions, no recommendations, just a gathering of the fact, which includes actually in the reports all the unredacted witness statements for the deciding officer to consider to allow them to come to a view.
Okay.
So it's very common for investigating officers to investigate the whole situation, if you like.
Okay. So you were compiling a factual report, or based on witness accounts, and presenting that to the Permanent Secretary. Can I ask what type of information was made available to Mr. Salmond and when?
So on the 7th of March, I think as was mentioned earlier, Permanent Secretary wrote to Mr. Salmond V's lawyers and included what are known as causes for concern, which were details of certain issues that she was asking him to provide a response to.
Okay, thank you. I also seen from my papers and what I've read and evidence thus far, Ms McKinnon, that there was some consideration given to the investigation process being an independent process. I wonder if you can confirm if that was indeed the case, and why an independent process at the end of the day wasn't pursued.
So I think this was something that came up early doors in the development of the procedure, and the suggestion that an independent IO was raised. I think in my evidence last time, though, what I talked about there was the kind of standard process that we already have in Scottish Government for investigating matters, like formal complaints. We've got a pool of investigating officers who tend to be, who are identified and trained, and we ensure that if they are investigating something, it's not something that they've been previously involved with. It tends not to be in their own business area, so that they have that independence.
Okay.
So this was an approach that's already embedded within Scottish Government, and that was certainly what was in my mind in the early stages of the procedure being developed.
Okay. And the procedure has no time scale attached to it. Do you consider that an omission?
No time scale in respect of
the complaints procedure, or are you working to timescales?
Well, timescales in relation to what? How long the investigation will take, or?
Well, there's various.
What do you mean by
there are various stages and processes involved in an investigation. Is it in order for an investigation to go on for as long as it takes, or is there some I'm asking you about your processes and your procedures. I can't find timescales. Is there timescales?
No.
There's no timescales.
No.
Okay, and you don't consider that an omission or problematic in any way? I'm just asking your opinion. You're someone with an HR background.
We certainly have timescales in other procedures that we have. It's not always easy to stick with them, and in my experience investigating matters, you never really know what's going to come out of an investigation, and what we are required to do is conduct a full and fair investigation. And until you start to hear from people and start to understand the number of witnesses, etc., it's hard to say how long it would take. but what we are required to do is to ensure that we do it timeously and without delay, if possible.
Okay, and my final question, Convener, and thank you for your forbearance, is Ms McKinnon, I wonder if you could just confirm the contact, or if you had contact with Miss Russell, the confidant, and if you had contact, whether that was before the complaints process kicked off or after, or both.
I had both. I spoke with Gillian beforehand, and I think I provided her with a bit of a framework to help her when staff were engaging with her, and then afterwards when she passed over certain things to us to deal with.
Okay, and a very quick supplementary to that. Where are the bounds of confidentiality here, bearing in mind the role of the confidant is to be a private sounding board separate from the organisation, separate from HR? Where are the boundaries?
Well, they're very, very clear boundaries, and it was for the confidant to, if the individual hadn't wanted the matter shared, then that would have been respected. Okay. So Gillian would not have shared anything with myself or Nikki without permission of the individual.
Okay, thank you. Thank you.
Jackie Bailey.
Thank you very much, Convener. There is a lot to get through there, so can I welcome Ms McKinnon back to the committee. Can I just return to follow up something that you said in relation to the police? Can I ask you, was a copy of your investigation report offered to the police by the Permanent Secretary?
I don't know. I wasn't involved in that part of the process.
Okay, would you be surprised to hear if it was? Because my understanding is a senior police officer certainly told the criminal trial that Police Scotland didn't want to see a copy of your report because it could contaminate their investigation. You have no knowledge of that?
So, not at the time. I didn't know at the time that had been offered.
Okay, but you obviously have heard of it since. Did you think that was a wise move on the part of the Permanent Secretary?
I don't know. I can't answer that question.
Okay, thank you anyway. You told us previously that you'd been very open about your involvement with the complainants in late 2017. So I'm curious to know, why did the Permanent Secretary and Lord Advocate claim that it was only during the commission of documents in December that they decided to throw in the towel at all? Had you not told them the full extent of your involvement?
So, as I said previously, I was upfront about the contact at the time and during the process. My understanding about the judicial review decision related to our ability to evidence fully what that contact had been. So prior to December, I think I had provided everything that was asked for, and it was considerable, and it included the substantial meeting with Ms E, or the substantive meeting with Ms E on the 5th of December, and all the contact and emails in relation to that in the December. The outstanding thing, sorry,
you carry on.
The outstanding things that came up as a result of the very specific information specification on the 17th of December, identified other places that we were expected to look for in terms of evidence.
Okay, so
and where...
Yeah. What you're telling me is that you were open and transparent about this since late 2017. Everybody knew about it. But for the judicial review, the process you went through was about providing the evidence to show that you knew about it. Okay, That's fine. So in December 2017, I think you told us before, you had meetings in person or by phone with the complainants. You and Miss Richards told them that you would be the investigating officer. I think you confirmed that to me after. In November, you had sight of what was later to become a complaint from Miss A, and the emerging policy was shared with one of the complainers. All of that was before the policy was adopted, wasn't it?
Before it was approved, yes.
Okay.
It was
okay.
approved on the 20th of December.
So I'm kind of curious, given all of that brought together, why you told us you were shocked that the judicial review had been conceded. I mean, you recognise now that that conduct probably would be seen as incompatible with being an impartial investigator?
I was shocked about the judicial review decision because I felt I had already provided the majority of information that illustrated the level of prior contact, and that had been done in the November. And our organisational position was still, at that point, these things were inserted into the pleadings, and our organisational position was to continue to defend the action. And so, for me, the finding of, felt to me, relatively minor aspects of evidence, or in one case not really being able to evidence that at all in relation to a particular meeting, felt like that's why I was so shocked that those things, those relatively small things, admittedly in my view, had resulted in the concession.
I think your prior involvement, which was substantial, as you yourself acknowledge quite openly, showed a degree of partiality that, small though it may be to you, allowed the Court of Session to arrive at a judgment had it gone to full term, but for the Scottish Government to concede before that happened, because they understood they would lose the case on that basis. That's not really a small thing, is it?
That's not what I meant about a small thing. Really, what I was indicating there was that the bulk of the information about prior contact had already been passed over and was contained within the pleadings. Okay. And at that point, you know, the other side were very clearly stating the bias point. So the final information that was uncovered and passed over, you know, it was evidence of administrative aspects of the prior contact and nothing more than that. And I think that's why it was such a shock.
Okay. The Permanent Secretary gave us an impression in her earlier evidence that she wasn't really involved at all in the development of the policy. Isn't it the case that you and Miss Richards briefed her almost every step of the way? So she knew the role you played during your time as the investigating officer and prior to it?
The Permanent Secretary was briefed on the prior contact, and once the investigation got underway, I certainly wasn't in regular contact with her at all. I had one meeting with her to give her the interim report. But that was the extent of the engagement.
So was Miss Richards briefing her then on the development
Miss
of the
Richards
policy?
She would be keeping the PermSec abreast of what she needed to know. She was in regular contact with her about a whole variety of things.
Can you remind me when you were appointed as the investigating officer?
So officially that would have been the 16th of January,
Okay.
2018.
Okay, so can I ask then, there is apparently a OneNote from the 9th of January from you, where you talk about changing position of a potential complainer. You talk about better to get policy finalised and approved before a complaint comes in. There's mention of Miss Richards updating the Permanent Secretary and of not telling the former First Minister until you were ready. All of that was before you were appointed, wasn't it?
before I was officially appointed, yes.
Oh, okay. Is that compatible with being an impartial investigating officer? Maybe that's a rhetorical
As I
question.
mentioned earlier, in December, in discussions with Nikki, we had decided I would likely be the IO, and we were progressing on that basis. Formal appointment on the 16th of January was as a result of a formal complaint coming in and the start of that investigation process.
Okay. Can I take us on to the conduct of the investigation? After your report was concluded, did you keep in touch with the complainers?
Yes, so I had provided them with regular updates on the progress of the situation as it developed until the point. So I think, as I mentioned earlier, at the end of July 18, beginning of August, I handed that over to Nikki Richards for 3 weeks because I went on leave. And then when I returned from leave, she handed that engagement back to me, and I continued to update the complainers on progress.
Okay. The committee is likely to have the legal advice provided to the former First Minister by Levian McRae, because my understanding is he's waived legal privilege. Did you share any of the information about the positions taken by Levian McRae provided to you with the complainants?
No, I didn't share legal advice or any documents from Levian McRae. I really just updated the individuals with progress, you know, as it would affect them. So, for example, the initial delay in a response from the former First Minister, the initial time frame that was provided by the Permanent Secretary was not to be met, so I let them know there's no response to the Permanent Secretary's letter for another however long, 2 weeks or whatever it was. So that was the kind of updates I was providing.
Okay, I'm clear from what you've just told me you didn't share documents, but did you summarise the contents of documents and share them with complainants? Or indeed witnesses, for that matter?
No, I wouldn't say I summarised documents. I would be making them aware of what they needed to know as it would have affected them.
So in that context, what I'm trying to get at is, did you share any information pertaining to the legal position advanced by Levian McRae on behalf of their client with any of the complainants or witnesses, whether it's summary version or otherwise?
So I think I need to check the specific documents, my specific updates, if you don't mind.
Okay, I'd be happy if you did that.
I would rather do that.
It would be very helpful if we don't receive the updates in the tranche of documents we're due to get, whether you could do us the benefit of providing them to us. Can I move on quickly to the judicial review, started in August 2018. You told us previously that it was your job to report developments to the complainants. Who gave you that task?
That would have been agreed with Nikki Richards.
Okay, and did she get asked to do it by somebody else? Do you know? Don't worry, we can ask.
I don't know.
Okay, that's fine. You told us that the meetings for the judicial review last time were 3 times a week. I think Mr. Caquette said it was almost daily. Whatever the frequency, I am genuinely surprised, understanding how the civil service like to record things, that there doesn't appear to be a minute, a OneNote, anything of those meetings. Did you record those meetings?
I didn't record them. I took my own actions away from them. And which effectively was updating the complainers. So I suppose my my record of those meetings would be the update emails that went to the complainers.
Fine, and we're going to get a copy of those, so that's very helpful. We heard from Mr Coquette about the prospects of sisting, which is postponing the judicial review, and the Lord Advocate also mentioned it in his evidence a couple of weeks ago. You were aware of that possibility, weren't you?
Of assisting the judicial review?
Yes.
I am not sure that I was.
Could you maybe check
I'm not
that?
sure.
Because I'd be curious to know whether you
Yeah.
informed any of the complainants or anyone else that the Lord Advocate was considering the prospects of attempting to assist the judicial review behind the criminal case. Okay, so that would be very,
Okay.
very helpful. Finally, when you were giving evidence under oath to the Commission on Documents, were you transparent about the extent of your contact with Miss A and Miss B before you were appointed investigating officer?
In the Commission in Diligence
Yeah, it was the Commission
session,
on
is that what you're referring
Documents.
to?
Yes.
Um,
I mean, did you tell them about
Oh,
the
my
extent of your
recollect-
contact?
So my recollection is that they were asking me, so and I'd never been involved in anything like this before, so it was very much about documentation, and it was very much about referring me to documents that I had provided and checking with me whether they were further documents in relation to it. So, for example, if a document said in it, as per our conversation or from our meeting, they were asking, is there a record of that conversation or that meeting? Could you go and check if there is? So that was the kind of the basis for the whole session. It was really about the documentation that was there, so referring to and all the documents had already been provided about the bulk of the prior contact. The one thing that I and I did leave the Commission with a commitment to go and do further searches. Because things like, for example, the meeting on the 16th of January, I didn't have a record of it, and I couldn't find a record of it. And they asked me again to go and check if I could do that. So that was the main purpose of the Commission in Diligence.
Okay, thank you very much.
Alex Cole-Hamilton, I understand, has a short supplementary.
Thank you very much for bringing me back in, Convener. Ms McKinnon, in answer to me earlier, when I asked you if when those complaints first came, or the concerns first came to light before they were made formal, if you had suggested that the complainers hang fire, if either you or anyone else had suggested they hang fire until there was a policy, to which you said no, and I understand that and accept it. But at that time, they were given a draft policy to look at, to sense check and to see if it might have helped their situation. Was that not in and of itself an indication that there was a policy coming down the tracks that would address their complaints and as such might induce them to hang fire from making their complaint formal?
We certainly were open with them about the fact that there was a policy underway. And you're right, we shared a draft and they knew it was a draft. And so, I mean, that's the facts of the matter. It wasn't about inducing them to do anything. It was just about, as part of normal process, to share with individuals considering making a formal complaint what a process might look like and what to expect as someone who would be involved in that process.
But I imagine you would have told them how advanced that policy was, and the effect of that might have been that they will say, well, in which case, we'll just wait a couple of weeks until this is signed off.
Certainly never had a conversation like that with any of them, and it was left to the individuals for them to come back and say that they wanted to make a formal complaint.
And final question, Convener, if I may. I asked you about who knew of the complaints, the existence of the complaints, and you gave a very defined list of government officials, including yourself, Nicola Richards, Barbara Allison. But we now know that John Summers, the First Minister's private secretary, met with a complainer on 2 occasions, I believe on the 20th and 21st of November. When did you first learn of those meetings, and what was his involvement in terms of liaising with those officials who were in the loop, as it were?
I had no knowledge at the time that that had happened, and actually I have only discovered those meetings through the preparation for this inquiry.
Really? Okay. So you're telling me that the First Minister's most senior civil servant who is attached to her office received a disclosure, but to your knowledge did nothing with it within the upper reaches of the civil service at that time?
Well, I'm saying I didn't know about it.
But you were the investigating
Personally,
officer.
that's all I can say.
Yeah.
Well, but I was investigating officer in when things kicked off in January. I didn't know that those meetings were happening at the time, and I only found out much, much later that they had taken place.
Okay, thank you. No further questions.
Andy Whiteman.
Thank you very much, Convener. Good morning, Ms McKinnon. Either in your opening remarks or in response to an earlier question, you said that following the November 2017 email from the Permanent Secretary to all staff, people came forward. Can you tell me roughly how many people came forward? Was it a handful? Was it tens?
I think there was about 10 or 11 people.
Okay. And how many of those, to your knowledge, were concerned with matters that were complaints against the former First Minister?
So I'm just pausing in terms of the jigsaw identification. So if you don't mind, I would like to come back and clarify that for
Okay,
you.
that's fine. No problem. So one complainer came forward in mid-December, and if I can draw your attention to, I think it's document YY050, which is an email of the 14th of December from Nicola Richards to Ms A, copying yourself and Nicola Richards into it. And it describes a number of options available to the complainer. It says that Nicky Richards will be on leave, returning on the 9th of January, but Judith is very happy to be contacted if you want to talk at any time. None of those options include the possibility of a complaint under the Fairness at Work policy. Was that intentional?
I imagine it would have been intentional in terms of the appropriateness of Fairness at Work policy and the subject matter that was being raised.
So in your view, because we heard from James Hind on the 25th of August that the Fairness at Work policy had a gap that he had identified in relationship to former ministers. But we also heard from Nicola Richards on the 25th of August, and I quote from her evidence, that complaints about third parties, which is in essence what a minister or former minister would be in this instance, are a fairly routine part of other policies and are included in our Fairness at Work policy. So I just want to know, had the complainer wished to complain under the Fairness of Work policy, would it have been admissible, given that it was a complaint about a former First Minister, even though there wasn't a specific procedure for that?
I would have said no. The Fairness at Work policy allows for complaints against current ministers, but not former. And that's where the gap that James Hind had identified and the HR team had also identified, that was a gap in our existing processes.
Okay, thanks. I just want to move on to the question of prior contact, because this same email from Nicola Richards says that in the case of it being a formal process, then it's likely that Judith would take the role of the senior officer, given she had no involvement at the time and her professional experience. Is it your understanding that the phrase "no involvement at the time" relates to any involvement you relates to involvement that you did not have when the alleged incident took place many years earlier.
That's correct.
Okay, thanks. That's helpful. Can I move on to the question, therefore, of prior contact? In general terms, in your understanding of the term prior contact, did prior contact have the same meaning as no involvement at the time?
So I think they're two different things. Prior involvement in the matter being investigated and prior contact with the individuals in terms of process, I think are two different things.
Okay, so no involvement at the time is clear, but prior contact with the complainers, how far back would prior contact have to be for there to have been no prior contact?
Well, I'm not quite sure what you mean by that.
Well, I'm just wondering because during your previous evidence session, you stated that the initial drafting of the procedure, the initial drafting, I'm quoting here, the initial drafting was very clear about the prior contact that could take place, and that is how I operated. So what was your understanding, therefore? Because it says the initial drafting was very clear about the prior contact that could take place, and that's how I operated. So what was your understanding of prior contact?
So my understanding was exactly what I did, you know, making sure that the individuals were aware of the options open to them and what the process might look like should they decide to make that formal their concern a formal complaint. So, and I think I'd said previously that's why I felt I was acting completely in line with the policy, albeit that earlier revised version of it.
Okay, that's helpful. Thank you very much. Could I move just forward to the point in time, I think in March 2018, when the former First Minister became aware of the nature of a formal complaint having been made against him. I think from what you said earlier that it was the Permanent Secretary made the former First Minister aware that a complaint had been made. Is that correct?
She wrote to him through his lawyers, I understand, yeah.
Okay. And the First Minister's lawyers then corresponded with the Permanent Secretary, and there's quite extensive correspondence. How much of that correspondence was shared with you, broadly speaking?
I saw correspondence that was anything relating to the investigation or anything that I had to update the complainers on. Okay,
so for example, when the extent to which witnesses were suggested by the former First Minister and the extent to which any witnesses were asked questions that he considered relevant, those kind of points would be drawn to your attention because presumably only you would know the answer to those questions.
Yes, so I would notify the complainers that, for example, the former First Minister has put forward witnesses for me to interview, and that will take place over the coming weeks. So just so you know, that's what's happening just now. I am now investigating and speaking to other witnesses put forward by the former First Minister.
Okay, and you did indeed speak to all those witnesses, did you?
I spoke to 4 of them and I received a statement from a 5th one, and the former First Minister himself provided a statement. Okay, and that was all then wrapped up in your draft report that you sent to the Permanent Secretary. That's fine, thanks. That was the final report that went to the Permanent Secretary. Yep, thanks. What do you understand of what's the relationship between your role as investigating officer and the role of the confidant? Completely separate. The confidant role was very much at the earlier stages of the process for people coming forward. However, one of the things that, so my role with the complainers on an ongoing basis was to ensure they were aware of progress and developments. I wasn't providing pastoral or emotional support, but I was giving them options where they could access that type of support. And those options included the previous confidant role in Gillian Russell. But there was also other options in terms of, external counselling support, for example.
And the role of the confidant, has that always been part of Scottish Government procedures as far as you can remember?
I don't think so, and I was really quite new into the organisation at that point. I only joined in August 17. I do think that the confidant role was introduced in particular in relation to this process, and that's the role that Gillian took on. However, I think that she's still identified within the organisation as someone that people can go to, so it's still an option that's there for staff.
Okay, thank you, Convener.
Thank you. I've just got a couple of questions to wind up with, Ms McKinnon, if you would. In the Permanent Secretary's, or one of the Permanent Secretary's letters to Levy and McRae, included details of anonymous complaints. And I'm just wondering whether you investigated any anonymous complaints.
Was she not referring to the two individuals who had made the actual complaints? Because their names were not shared at that stage with the FFM.
So you don't think there was anyone beyond that then?
I don't think so. I'd have to go and check, but I'm sure it would just be the two complainers who had asked for their names to be kept anonymous.
Okay, thank you. And talking about the complainers, I wonder if either of them ever expressed a view to you and the extent of the independence of the policy or the process as it was going forward.
Not to me, they didn't.
So
no.
You felt they were confident with it?
They certainly didn't say they weren't.
Right.
They didn't express that view.
Okay, thank you. The last thing I wanted to ask you is back to the beginning of this session when we were talking about discussions with the police, and you were quite upfront when you said as an HR professional that there was a reluctance of the two complainers to go to the police, and you were asked to sound them out by Nicky Richards. Can I ask you, as I say, in your view as an HR professional, when people are raising complaints of a serious nature like this, is it generally the case that people would have, when I say encouraged, I don't mean that in a bad way, I mean it, people have to be given the confidence to either go to the police themselves or to agree to allow their employer to go to the police? Would that be the case generally?
Yes, generally, absolutely. Individuals have always got the opportunity or the option to raise a complaint. If someone, they've always got that opportunity to make a complaint at any stage.
Yeah, but actually going to the police about it, is that something that understandably people would be reluctant to do?
I can't imagine it would be an easy thing to do. At all. I can't speak for the individuals, but I can't imagine for 1 minute it would be an easy thing to do.
And do you think there's any particular obligation on an employer to encourage people to do so?
Well, I think as the policy states that, that the Scottish Government may consider making a referral to the police if they consider that there's potentially something criminal has happened. And that's exactly what happened in the end. But I think that before that decision was made, there was obviously considerable information and facts gathered about the complainers' experience, and with all the evidence that was finally produced for the deciding officer's report, that decision was obviously felt to be the right one.
Okay, thank you very much. I think that's all our questions. Thank you very much for coming with your evidence today and for the time you have given to us. And we'll now have a short break of a few minutes before we move to the next witness. Welcome back, and can I welcome Gillian Russell, who's the Director, Health Workforce at the Scottish Government. And may I begin by inviting Ms Russell to take the solemn affirmation. Please raise your right hand and repeat after me. I solemnly, sincerely and truly declare and affirm
To solemnly, sincerely and truly swear and affirm
that I will tell the truth, the whole truth and nothing but the truth.
that I will tell the truth, the whole truth and nothing but the truth.
Thank you. And I would now invite you, Ms Russell, to make a brief opening statement.
Thank you, Convener. This opening statement is to give some background to my career as a civil servant and the context to my role as confidential sounding board. I have worked in Scottish Government since 1992. The first part of my career I worked as a lawyer, being promoted to senior civil service in 2007 and then moving into policy roles in the Justice portfolio in 2010. I was appointed as Permanent Director of Safer Communities in December 2015 with the Safety, Security and Resilience Brief, including the Police and Fire Service. On 17th March 2020, I moved to my current role as Director of Health Workforce, working on the COVID response. Turning back to autumn 2017, the SG, like other organisations, was reflecting on the issues raised by the Me Too movement, with extensive media reports and focus on sexual harassment in the workplace. By end October, early November 2017, there was both an SG and UK civil service-wide expectation of an effective response, including the creation of a safe channel for staff. It is documented that our organisation was picking up concerns from staff following the all-staff message on 2nd November and PermSec blog on 6th November. On 10th November, the PermSec asked me to take on a corporate role in relation to sexual harassment. The role was communicated to the Scottish Government through an all-staff message on 13th November. In that note, the PermSec advised that I was to act as a confidential sounding board for those that had experienced sexual harassment, whether current or in the past. It was made clear that this was not to supplant existing arrangements, but to provide another option for those who would like a private, informal and supportive space. I was very mindful that the people that might come to speak to me might be fearful in taking the step to speak to a senior official. In response, it would be important to develop a relationship of trust and confidence, in particular that they could speak to me in complete confidence. It was important to understand what mattered to the individual and support them. I considered it important that any issues raised with me were taken seriously and dealt with promptly. I anticipated that the things they shared with me could be distressing. This is a role that I have continued to do. My details remain on the internal SG staff pages. It was in this role that I was approached by an individual for support that became Miss A. I met with her, took a note of that meeting and passed that note to HR anonymously on her behalf on 22nd November. On 29th November, I engaged with Miss A on behalf of HR to ask her to speak to HR Direct. She agreed. I had no further involvement in the steps that followed in relation to the engagement that then took place with HR. I am not giving evidence to this committee on my own behalf, but on behalf of ministers. This is complex legal territory and I am privy to information that may have been subject to legal proceedings, to which confidentiality is claimed by other parties, or goes to the heart of the integrity of the role I was given. I will try to answer questions to the best as I can, but may need to pause for legal advice or follow-up questions in writing with detail, to ensure accuracy and to ensure that all the government's legal duties are fulfilled. In line with the approach of other attendees, I declare that I am a member of the FDA Union. Thanks, Convener.
Thank you very much, Ms Russell. Can I just ask you a quick question before we move on? We heard from Barbara Allison about her role in pastoral care. And I just wonder if you could clarify for me the difference between your role as confidant and the pastoral care role that was undertaken by Ms Allison?
Yeah, so the role that I was asked to do by the Permanent Secretary was around the confidential space, the conduit, as she described it to me. She said that she was looking for someone that staff could approach and that had experience of dealing with sensitive issues. So to be honest, at the time in November, and the documentation will demonstrate this, I wasn't aware of Barbara Allison having had that role of pastoral care. What I was aware of was the role that the Permanent Secretary asked me to do. And I think the origin of it can be traced back to the letter that she'd received from Sir Jeremy Haywood at the time, which had asked for a safe, a person that could provide that safe role within the UK civil service. So that was her answer to that.
So is it a case of people going to you direct rather than being referred to you?
Yeah, so I think it was important to recognise that the role that I had was there if staff wanted to take up that option. So the role was promoted to the civil service in an all-staff message on the 13th of November, and the committee will have seen that all-staff message, and that staff message did make clear to staff the basis on which they could come and speak to me, and it's as I set out in my introduction. So that was a very clear message to staff around that, and on that message going out to staff, I simply waited to see if anyone did want to approach me that wanted to raise any matters with me in relation to sexual harassment, either current or historic. And so obviously I waited to see whether anyone would take up the offer that had been made to them of a senior civil servant in that space.
Thank you for the clarification. Can I move, please, first of all, to Margaret Mitchell?
Thank you, Convener, and it still is morning. Good morning, Ms Russell. Just to clarify what you said to the Convener there, can I be clear then there was no interaction between you and Barbara Allison in her role as pastoral care officer and yours as the confidant?
Yeah, so it'd be helpful just to articulate that a little bit further. So after I took on the role on the 13th of November, there was an engagement with Barbara Allison, and Barbara Allison advised me that there might be somebody who might want to come and speak to me. I advised Barbara that as had been set out to the organisation, I could be contacted. There was a text number made available to staff for that purpose, and that if anyone wanted to contact me, obviously I'd be very happy to see what I could do to support them as had been set out in that note. So the person then did get in touch with me, and that became Miss A.
She knew someone wanted to talk
She just said to me that there was somebody that might want to speak to me, and she passed on. And I said, well, if there's someone that wants to speak to me, please can they do that through that text number, and I can obviously speak to them and see what they would like to do next, and that's how that started.
And she didn't give you any context about how she knew about this person?
She would have said that she'd been approached by somebody that wanted to speak. And that was all I knew, yeah.
Okay. Can I ask, did anyone who came forward to you to raise concerns about historic sexual harassment indicate to you that they had raised these incidents with anyone at the actual time the incidents took place?
I'm not sure I'm allowed to go into that level of detail.
It's a general
before
question,
the
you know,
committee.
had they raised it with anyone at the time? No specifics.
I'm just being careful because of the risk around jigsaw identification. It's not that I'm trying to be unhelpful to you as Deputy Convener. If I'm asked truthfully, yes, they had.
That's helpful. And you're not able to say, or are you able to say who they'd raised it? For example, we know from the FDA evidence. There were a lot of people who had raised concerns but not formal complaints. We know a lot of them sometimes raised them with their line manager. Were they able to say, if not a person, you know, generally a sort of
I'm just
post?
being careful again about the constraints that I'm under. Just in general terms, had been raised within their own internal line management.
Mm-hmm. Yeah. And are you able to confirm or not if Barbara Allison was informed about them at the time?
I have no knowledge of that at all. As far as I recollect, it was their internal line management arrangement that had been fully advised.
Okay, thank you. Could you confirm how long your role as confidant to the complainer lasted? For example, once the complaints passed to HR and were formalised, did your role cease or did you continue to provide support throughout? Yeah, and is that including up to the judicial and beyond the judicial review?
So I know that unfortunately you haven't had the documents, but I think the document in my last email to Miss A made clear that I would continue to offer support for her if she wanted that. And I have seen the further documents, which I didn't see at the time, but I've seen them in the subsequent documents that are being produced to the committee, advising Miss A that I would be available to provide support to her if she wanted it. I can confirm to you that she didn't take up that offer of further support during that process, but obviously if she'd asked for further support, of course I would have given that.
Okay. You were obviously then in contact with the complainants during the judicial review period, or you know, you had the ability to be. Were you aware of the offer of arbitration having been made by the former First Minister?
So just to be clear, I wasn't involved with the complainants during the judicial review process, and in fact I didn't have any engagement with the judicial review process prior to being asked to attend at court in the Commission.
I understand that, but I believe then the offer of arbitration came way before the judicial proposal. You weren't aware of the offer of arbitration being made at all?
So post the 29th of November, I didn't have any knowledge other than I think I would have been advised that there were formal complaints going forward, but the nature of what happened in that process, there was no reason for me to be told anything about that. There was no basis for me to be involved in any of that at all, so I had no knowledge, just to be clear on that.
So you had no knowledge at all that an offer of arbitration had been made. When did you become aware? I mean, we're all aware of it now. When did you become aware?
Only when these papers, I wasn't aware of that until these papers were presented.
That's helpful, okay. Thank you. Without going into the specifics about individuals, can you say generally, from those who contacted you, did they have a clear outcome in mind? Were they clear they wanted to make a complaint, or did they just wish to speak to someone?
So I suppose in terms of the role that I took, bearing in mind that I have a confidence the people that spoke to me, people came and spoke to me about current and historic issues, and each of those was unique and required its own set of discussions. So really my role was to see what the individual wanted, to listen to what their concerns was, and to consider with them what options there might be. Some of that might have been moving them into a formal HR process if that was something that they wanted. Sometimes it was to help them to speak to a line manager. Sometimes it was just to record their recollections of the culture of the organisation. So there were many different ways in which I would have supported somebody. There wasn't a particular route.
Yeah, I understand that. In terms of the options that they might have been looked at, we know mediation was raised, and whether that's appropriate or not in these kind of ventures is another question, dubious. But was that an option that you knew could possibly was offered, and that's something, if they wanted it, it could be considered? And was the option of them going to the police something also raised with them?
So I think I'll constrain my comments here to Miss A, because I think that's really the subject matter of the committee's consideration in relation to the complaints. So clearly in terms of the statement I took from Missy when I spoke to her on the 22nd of November, she raised a series of very significant issues with me. And I obviously found what she said to me profoundly difficult, actually. So I'll just be honest about that. And in response to that, we did discuss some of the things and issues that she may want to think about in taking matters forward. I don't want to go into too much detail, but you've asked specifically about the police. I think at the time I did record that I thought that it could raise, it could potentially raise matters of a criminal nature. I did record that at the time.
Can I ask you the reaction to that? Was it, well, that's a step too far?
Well, I think at the time she had only just come and spoken to me. It was not, and as you can imagine, a very easy meeting, and obviously I just wanted to be compassionate and thoughtful about what she would want. And I think, you know, I've said in the introduction, as somebody who'd worked in the justice system for a long time, I was very mindful of the need to be very careful around somebody that had revealed something of that nature to you, and the kind of considerations that you would need to take. So, you know, it was not a decision point. We agreed on the back of the discussion that it would be appropriate for me to put a note of that meeting to HR anonymously on her behalf. And I gave HR a relatively detailed note of the issues that she had raised with me and the discussion that we had had. So HR had that at that point on an anonymised basis because that was her wish. And it was the meeting that you mentioned Barbara Allison. Barbara Allison attended at that meeting as well. And she and Missy had considered the note of the meeting, and that anonymised note went forward to HR.
Right. If I could ask you, what was your understanding of your role in relation to the police? Were you to contact the police in the event of a concern raised?
So I'd asked at the outset on taking on after being asked to take on the role by the Permanent Secretary, I'd asked for some specification about the nature of the role and what that might entail, and actually also what I might do in terms of people that might come to me. So that specification was given, and the committee will get that detail in due course. And I also asked separately for a checklist because I was concerned that people might come to me in distress. They could come to me with significant live issues that they were facing, and it would be important for me to have some framing for any conversation. And that checklist, I think, can be made available, will be made available to the committee as well. So in that context, it was just important for me to engage carefully with that individual.
So you're able to set out what the process would be for taking a matter to the police. Were you clear about that?
So I'd asked at that point in time about a police liaison officer generally. So just to be clear, my role was in relation to current and historic issues. It was not particularly in relation to ministers. It was any staff who had come forward with any issues. And so I had to be mindful that current staff could be facing current difficult issues, and I might need to intervene. Okay, so I'd asked if there was a police liaison officer that could be made available, would be known. So there was an opportunity if an individual came to me and said, this is what's happening to me, we talked it through, it was significant, I thought it raised matters of a criminal nature, they wanted to go and speak to the police about it, of course I would have supported them to do that. I have a lot of confidence in our police and their ability to engage around issues of sexual crime. I think they have a very, very high service there. So that was one option that could have been taken. separately, if somebody didn't want to do that, that was fine because they didn't want to, but I wanted to understand what the obligation might be on me as a senior civil servant who had that information, or what obligation there might be on the organisation. And I think in the information that you will get, there is some reference to me asking that of Judith McKinnon, and on advice on that matter, I was advised that there would be HR involvement and there would want to be further discussion and consideration around that. So as far as I was concerned, advice had been given to me and it was quite clear, and I think subsequently the PermSec's written to say a bit more about that generally. So I suppose just for your reassurance, I was very alive to that issue, but also very mindful and thoughtful about the need to be supportive of the person that had chosen to speak to me.
And you didn't have anything to do with the generic meeting that, you know, happened with the police, the liaising off, and
No.
so, you know, explaining
No.
anything. Finally, if I could, convener, were you involved in the discussions on the referral to the police?
No.
No, so not at all.
No.
Okay. Were you aware of which officials were involved?
No, I did provide to Judith McKinnon the public protection names of people that I thought, because of our role advising, working with the police generally on policy-related issues, I would have known the part of Police Scotland that would have public protection specialism. So that name was given to Judith McKinnon. I've looked at the documentation, the name is redacted, and I've been advised that that's because there isn't considered to be a need to release that name. So I do know the name, but I'm not going to give it for that reason, if
fine.
that's okay.
Can I just ask then how you did become aware there was a referral and who told you?
So I didn't know that until it became public knowledge in August 2018. That was the first I knew that the matter had got to that point. Pardon?
Did you read it in the
I
press?
heard it in the press, that's correct. Yeah.
Thank you, that's very helpful.
Okay.
Thank you. Andy Whiteman.
Thank you, Convener. Good morning, Ms Russell. I have to leave at 12:20, so it's no disrespect to have a meeting with the Cabinet Secretary. You took on the role of confidant role as requested by the Permanent Secretary. Were you aware at the time you were asked to take on that role that there was a review underway of how complaints regarding sexual harassment would be handled by the Scottish Government?
So at the point in time I took on the role, no, I wasn't aware of any of that and I hadn't been involved in any of that. I think the record will show, and again, sorry you don't have the documentation, but Judith McKinnon did share for reference a copy of draft guidance, the draft guidance on the 24th of November. And that was the first I would have been aware of that.
And did that have any bearing on the confidant role that you were undertaking, or would it?
I mean, the confidant role was in relation to all staff, and it just so happened that some staff that came to speak to me happened to come to speak to me about matters in relation to the former First Minister.
You say some staff, were there more than one, or how many?
I won't go into any more detail if you don't mind, but it's fair to say there was more than one person, yeah.
Okay, that's fine. So once the complaint had been formally received by the Scottish Government in January in relationship to Ms A, what was your role? Did it just continue to be a confidant?
Yes.
And did you have quite significant engagement with Ms A during that process?
No. As I said to Ms Mitchell, I didn't have any engagement with Ms A at all. She didn't choose to come back to speak to me further.
After the 22nd
After the 29th of November, when I had the email exchange with her and she agreed that she would speak to HR, and I removed her anonymity at that point for HR because she'd agreed to speak to them, and I said, you know, I'm here if you want anything, but she chose not to get back in touch.
So your actual engagement with Ms A was over a relatively short period of
Correct.
a week to 10 days
Yeah.
or so?
Correct.
If I can just turn to the investigation that was underway. Were you told that that was underway or not?
So I wouldn't have known anything other than I think there is a reference in documents I've seen in January or February to a discussion between Nicky Richards and Judith McKinnon suggesting that out of courtesy they might want to tell me that these things had moved into a formal process. Now, I can't recollect whether I was told that, and certainly I didn't know anything at all about anything post the 29th of November. At most, they must have said, they could have said to me that there was now a formal process, but that is the limit of what I would have known. I didn't know anything further.
And were you satisfied in relationship to the advice you were given about record keeping, for example, what your duties were in relationship to the things that people divulged to you, to what extent you should maintain a permanent note of that? Were you satisfied that you had sufficient guidance on that question?
So I think it is an interesting point because obviously people were coming to me in a quasi-independent role with a certain expectation that I would hold things in confidence and it was to be an informal private space. But at the end of the day, I still was a senior civil servant, so there were still obligations on me as a senior civil servant. So I did keep notes and would have disposed of them as appropriate. In relation to the individual matters that I was dealing with. Some notes I obviously have had to keep, yeah.
And in relationship to your role as confidant, was it clear to people who came to you that they would have the final say in what, if anything, you did or to whom you may speak about their matters?
I tried as far as possible to do that, which explains why when Miss A spoke to me initially, I put the note I'd taken of the meeting on an anonymised basis and kept her identity separate. I think, given what I've said already, and it was an issue I'd raised initially with both Nicky Richards and Judith McKinnon, given our obligations as an employer, and bearing in mind that people were raising issues that happened within the workplace, inevitably, if significant issues were raised with me that might have required us as an organisation to respond, notwithstanding the duty of confidentiality, there may have been circumstances where I would have found that difficult to have not had taken some action. I mean, clearly I would have done all of that with the individual and I would have spoken them through that, but I think there were boundaries to this sense that I could just keep everything completely confidential. There would have been boundaries.
And just finally to confirm, you talk about anonymity. Did Ms A reveal who she was to you when she came, or did you insist that that shouldn't be the case?
I met with Miss A in person, but she was clear initially that she wanted to give an anonymised account, which is what I facilitated.
And that was an anonymised account to, well, it wouldn't be anonymised to you. What was the
It was anonymised so that she wasn't named in the account, and some details were taken out of the account to try to disguise her identity.
And when you say account, that's an account you were keeping contemporaneously with your discussions with her?
It was a detailed note of the set of issues that she described to me of her experience in our organisation.
And just finally, sorry, that note, did you then pass that on once the formal complaint was
So
made?
the note was, so I met her on Wednesday the 22nd, I think, in the afternoon. And given the seriousness of the issues that she raised with me, I produced the note and sent it to HR at 6:35 that evening.
And she was content
With
that
her,
you,
yes,
with her
because
consent?
she had seen the draft and she was content with the draft, and it was sent that evening.
Okay, thanks very much indeed.
Thank you.
Thanks, Gundina.
Okay, Alistair Allen.
Thank Convener, earlier on, Judith McKinnon mentioned how you had appointed her as investigating officer. Can I ask if you can say any more about how that appointment was made, who else was
Involved in any of that at all.
You weren't?
I didn't have any involvement after the 29th of November.
Okay, I beg your pardon. In that case, can I ask, in terms of your own involvement, whether you reported to the Permanent Secretary?
So I spoke to the Permanent Secretary and she asked me to take on the role on the 10th of November. She made it clear that if I was to engage further about the role, I should do that with Nicky Richards and with Judith McKinnon. So I duly reported, and I think the agreement was that I would initially review with Nicky and Judith issues that came to me on a weekly basis as appropriate. So obviously, once the announcement had been made to the organisation on the 13th of November, there were a few things that came to me, and I engaged as appropriate with Nicky and Judith in that time frame. I am aware that that Nicky gave a high level, and I think this will be in the documentation that you get, note to the Permanent Secretary that reflected that both myself and Barbara Allison had received a concern in relation to a former minister. And that, I think, note went to her on the 23rd of November. I didn't actually speak direct to the PermSec about any of the matters I dealt with. Everything I did was through Judith and Nicky.
Thank you. You've described the role of confidant, I beg your pardon, earlier referred to it as investigating officer by slip of the tongue. But you referred to that role. Did you feel that the way that role was formulated left it sufficiently independent to be useful?
Yeah. So I'm quite an independent-minded person, and I had been given that authority by the Permanent Secretary, so I did as far as I could carry out that role in an independent way, but I was mindful that I was not independent, I was a senior civil servant. And I did raise that issue with Nicky on the 29th of November, some early reflections on the role, and I think you'll get this in your documentation as well, that one of the issues I did have in my mind was whether the role was really sufficiently independent and whether it would be something to be considered about having a truly independent role rather than somebody that was a senior civil servant doing the role. So that was certainly one of my reflections in relation to the role.
You mentioned also the boundaries as you saw them around issues of confidence. And can I ask if you can say whether you felt those boundaries were effective, whether they allowed you to do your job, what you consider those boundaries to be?
Yeah, so I think it was really important for me to understand what an individual wanted, and that required me really to meet, engage and discuss issues with whoever the individual was that came to speak to me. So it's an important role, I think, in listening and trying to seek to understand what that individual wanted, and then to talk them through what sorts of things might be a good next step for them, what could help them where they currently are, what might make a difference. And that was really the way in which I would have approached anybody that came to speak to me. And you know, regardless of the circumstance, I treated each person with the same level of seriousness, because I thought that it was a big step for somebody to take to approach really a stranger that they had found their text number on a staff message. So I did take every person who came to speak to me seriously. And some of them would have had concerns, for example, about their line management or whether they had confidence in the HR processes. So some of that was about just helping and talking people through things. Other times people just really wanted somebody just to offload about something, to talk an issue through. Sometimes I might suggest people would speak to the trade unions, signpost them to the employee assistance programme, suggest that they might need some counselling. I mean, there was a lot of different options, I think, open to people once we started discussing things through. But as I've said already, I always recognise in the role there may be things that were referred to me or revealed to me that were of significance, bearing in mind that we are the employer in the organisation, that I would have to do something more with that. I would say in all of the people I dealt with, that every step that I took was with people's consent, and broadly with I did things at a pace that people felt comfortable with. I don't know if that's helpful.
Well, it is. I mean, finally, can I ask, you alluded to the issue of independence there earlier on, and the need for it. I mean, one of the things we're doing as a committee is attempting to find lessons that can be learned for the future. Do I take it from your earlier answer that you feel that a lesson we should learn is around the issue of whether some of the role that you were undertaking should have been undertaken more independently?
Well, I wasn't truly independent, was I? I was still a senior civil servant, so I think that's something certainly for the committee to consider, and I thought perhaps something that Laura Dunlop QC might consider as well as part of the review that she's currently undertaking.
Thank you, Convener.
Angela Constance.
Thanks very much, Convener, and good afternoon, Ms Russell. Given that the role of investigating officer and the confidant is entirely separate, I wondered if, therefore, there is any merit in only one person having conversations with a potential complainant before a complaints process starts. And I wondered, and I appreciate you're not here to give a personal view, but I wondered if that issue of process was considered by the organisation at all.
So I suppose I would have viewed the role of confidant as separate, really, because people were coming to me as set out in an informal, supportive, private space. There was no expectation at that point that those people would ever go into a formal process or necessarily even go to HR. So I suppose the point is that, you know, you've got to understand, if people are coming to speak to me, it's perhaps because they don't have confidence in the more formal parts of the organisation, or they've lost faith. So there was something for me about that opportunity of a safe space for people to step into, where they felt that they could be listened to, and they would have a person who didn't have any formal attachment to HR in that sense, that they could talk things through with that person. And I suppose that's why I also thought it was important, because often trade unions can play that sort of role. And I had at the outset said I wanted it made clear in the staff notice that I wanted the trade unions to know about the role and to be happy with the role, but also that the staff notice would be clear that I was only one of a number of routes that staff could go down if they had issues around sexual harassment.
Yeah, and I appreciate that it is entirely separate, the role of the confidant, but bearing in mind there are different routes that people can pursue, it is therefore, you know, possible for people to be pursuing different routes at the same time or in parallel. And therefore I wondered if that added to the case for the need for the confidant to be external to the organisation.
I mean, for the reasons I've already given, I think it's worth considering the nature of the independence of the confidant role and how compatible it is ultimately with some of the duties that might be upon you as a senior civil servant in the organisation.
Okay, thank you very much. Thank you, Convener.
Alex Cole-Hamilton.
Thank you very much, Convener. I only have a couple of questions. Thank you for coming to this today, Ms Russell. I'm very interested to know, to your knowledge, who in the civil service had first contact with the complainers about their complaints? I'm not talking about, notwithstanding the fact that in one case we understand that there was an informal process contemporaneous with the actual events themselves, but in 2017, who was the civil servant with whom the complainer or complainers had first contact and made their first disclosure?
So I had no contact at all with Miss B. So I have never had any engagement with Miss B. So just to make that clear, in relation to Miss A, clearly she had, and I can see from the documentation, been asking to speak to somebody about the concerns that she had or her experience. As far as I'm aware, I'm the first person that she spoke about her experience in total with.
Okay, and thank you for that. And roughly on what date, I mean, or you don't have to give an exact date for jigsaw identification purposes.
It's fine. I mean, I
Okay.
think I've said already it was the 22nd of November that
The
I spoke
22nd
to
of
her
November.
at length. Yeah.
Okay. So we now understand from documents that came with the Commission of Diligence in the Judicial Review that, in fact, the First Minister's private secretary met with complainer Miss A on the 20th and the 21st of November, and that she may have made a disclosure to him about the complaints that she wished to make. So that would make him first contact. Is that your
So
awareness?
I am aware of that, but that's not something that she spoke to me about, and it's not something I've ever spoken to him about.
So your knowledge of John Summers' involvement in
I
this...
didn't have any knowledge of his involvement until I saw it in the paperwork.
Right. Okay, that's fine. Thank you for that. I think I'll move on to a different topic, and that will be me. This is my final question then. So you said in your opening remarks that you retain this role, the Confidential Sounding Board. Has anyone approached you about the conduct of former ministers since the collapse of the Judicial Review?
So I've said I've retained the role. I don't think the role's really been promoted in the organisation since August 2018. So in August 2018 it was promoted in light of that. I do have the staff message here. So some people came forward to me in August 2018, that short period after that. Since then, a couple of people have come forward on very different issues in relation to ministers. As I say, August 2018, clearly because of the focus around that, of the matter being referred to the police, etc., I did have some people come to speak to me at that point in time.
I understand. And do you think that the fact that the procedure for the handling of complaints against former ministers remains in place in an unamended form and potentially exposed to the same kind of legal challenge as the former First Minister mounted? Do you think that might act as an impediment or inhibiting factor to anyone coming forward subsequently?
I don't actually have a view on that. I would hope that people would have known that the role was available and that I was a trustworthy person. They could still come and speak to me.
Okay, thank you. No further questions for me.
Jackie Bailey.
Thank you very much, Convener, and good afternoon, Ms Russell. You used to be, I think you told us, is it the Director of Safer Communities from June 2015, which put you in charge of the police?
Correct.
Excellent. Judith McKinnon was the Head of HR Governance at the Scottish Police Authority from 2015.
Correct.
So you would have known each other reasonably well in the course of your everyday work?
I didn't know Judith well. I knew Judith. I can say I knew Judith because I'd had one particular engagement with Judith in relation to, I think it was the recruitment round for the Deputy Chief Constables. I think it was a recruitment round that Will Kerr was appointed a Deputy Chief Constable, and she was involved in that recruitment round, and I happened to be involved in that recruitment round in a very limited way, and that was my main engagement with Judith McKinnon. Other than that, I would have known that she worked for Police Scotland, but I didn't have regular engagement with her.
That's very helpful to know, just the context. Now, you said you weren't the one who reported the matter to the police, but in terms of questioning, you indicated that you would provide contact with the police of the complaints if it was appropriate to do so. Can I ask you on how many occasions you've actually done that?
So I haven't had to do that.
Not at all?
No.
Okay. Were the police aware of the complaint from Miss A? You didn't provide them with any contact about what she said?
That would have been completely inappropriate.
Okay. Do you know who did?
No, I don't.
You don't. But somebody clearly in the organisation would have contacted the police on her behalf.
I wasn't involved in any of that part of the process, so I don't know that.
Okay, that's fine, thank you. The Chief Superintendent, who was the head of public protection, was named in the courts. That was Detective Chief Superintendent Leslie Bull. She was the one who told the court that Leslie Evans had offered the full investigation officer's report. Her name is obviously in the public domain because she testified in court. Is that the point of contact you had within the police?
So I've been advised that the name has been redacted for a reason, so I'm not going to say anything further about that. Okay. More generally, I can say obviously that I would know Leslie Bowles. She was highly thought of. She had a very strong role in relation to public protection. So I did know Leslie Bowles. I would have met her in my professional role as Director for Safer Communities.
Sure. Okay. The reason I'm curious is to try and identify when the police first knew about the allegations that were made, so you appreciate why I'm asking the question. Did Miss A tell you about the informal resolution arrived at by the former First Minister's office in December 2013?
I don't have the statement that she gave me in front of me. I was aware in detail of the circumstances, I think it's fair to say.
Did you put that informal resolution in December 2013 into the alleged assault of Miss A in the anonymised memo which you then sent to Miss McKinnon?
The note was detailed. I don't think I should go into any more. It was a detailed note of her experiences in the organisation. I think that's sufficient.
That's very helpful. I'm not pressing you for detail at all. I'm just trying to follow the chain of events and who knew what when. So there is the potential on the back of that informal note for the police certainly to have knowledge of the allegations about the former First Minister since late December 2017.
My note was a detailed note of what she explained to me, a detailed note.
Thank you. I take the point you're making to me, absolutely. In terms of that note, you obviously shared it with Judith McKinnon. Did you share it with Ms Richards or Ms Evans?
So the note was sent for your eyes only on the 22nd of November to Judith McKinnon and to Nicola Richards. The other people that had the note was Miss A and Barbara Allison.
Okay, thank you. When you shared the note with Judith McKinnon, were you aware that she was going to be appointed investigating officer?
No.
No. When you found out that she was appointed investigating officer, did you think to raise a question about the difficulty inherent in her prior knowledge of the complainants and indeed the policy as you understood it?
So I don't think I would have been necessarily aware that she had been appointed as investigating officer. In any event, even if I had understood that they were taking full advice, I would have expected them to have got full advice on that matter.
Okay. Did you, given your legal background, see a problem? I mean, I appreciate you saying they had other people to take advice from, but I'm asking whether you saw a problem.
I wasn't aware and I wouldn't have had a view. I wouldn't have thought it would have been appropriate for me to have a view on that.
Okay. Mr Cole-Hamilton asked you about the meeting with the First Minister's Principal Private Secretary that you didn't know about. Is it conceivable that Miss A was referred by John Summers to seek you out?
I don't think that would matter. I mean, the note had gone out to the whole organisation. What did it matter how she decided to come and speak to me? It wasn't relevant.
I guess it's of interest to the committee, and you said yourself that your role subsequently hasn't been well advertised, but she had herself been trying to speak to you and clearly didn't know who you were in the organisation. So I'm just wondering if quite properly, she was rooted in your direction and referred by...
I don't know. She never said.
Know.
She just asked,
Okay.
texted me and said, could I come and meet you? And I said yes.
Fine. Thank you very much.
Don't think there's... Oh, Alex Cole-Hamilton? Yeah, Alex Cole-Hamilton.
Just
and then-
thank you for bringing me back in, convener. Just two very quick follow-ups. Just a very quick one following your very last question answer to Jackie Bailey there. She texted you asking to come and see you. On what date did you receive that text?
So I don't have that text. She would have texted me after the 13th of November. The phone that I had, and I did explain this at the time, was defunct in the summer of 2018. So I had a BlackBerry, it broke. I got an iPhone in replacement. The texts that had been on that BlackBerry were not kept. But it was in the period from the 13th of November. I have my calendar from the 22nd of November, so I know that it was the afternoon of the 22nd of November that was blocked out. I think I would have tried to, I tried to, anyone that contacted me, I tried to arrange to meet them as quickly as possible at their convenience, and I think that was the first date that suited her. So she would have approached me between the 13th of November and me meeting her on the 22nd.
But it's unlikely to have been the exact day before. So what I'm driving at here is that I think it's very interesting that she would have perhaps reached out to you a few days before that meeting on the 22nd and independently had a separate meeting with John Summers as the First Minister's private secretary, rather than him being the conduit of referral saying, well, there's a sounding board, you can text Gillian Russell.
So she'd obviously reached out to Barbara Allison because Barbara Allison had spoken to me. So clearly she was looking to see who she could speak to. And, you know, you've got to remember in the context of the Me Too movement, people had a different perception, and it was a very difficult time for women who had been subjected to previous behaviour. So, you know, it's perhaps not surprising in the context of what was going on more widely that people were looking to share the circumstances that they'd found themselves in.
No, I understand that. No, I appreciate that and fully accept that. Okay, completely unrelated follow-up to my earlier line of questioning. And forgive me, I may have misheard you here, so correct me if I'm wrong. But you said in your answer to my earlier question that the last time that you'd been using your confidential sounding board in respect of former ministers was when the news broke of the investigations, the government investigations. You said that other people had approached you at that point. Was that about the behaviour of the former First Minister?
Yes.
And were any of those taken forward?
So at that point in time, I was quite clear that given that it was now going to be a police investigation, that it wouldn't be appropriate for me to hear the substance of any issues that people wanted to raise. And instead, if people did approach me, obviously concerned, worried, they might want to speak up, that at that point, the most appropriate thing to do would be to offer them. There was a number that the police had provided, to provide them with that number and just to provide them with reassurance that you know, the organisation was supportive and the police would be supportive. So that was the extent of my involvement at that point.
So is it fair to say that when the news broke and everything that came with that, that effectively the government abandoned the use of the procedure for the handling of harassment complaints in respect of the complaints regarding the former First Minister, and everyone who had a concern was directly referred to the police rather than starting a new process within the government.
So clearly, the fact that there was then a criminal investigation, that would take precedence over other things. So I don't know what decisions or discussions there were in government, but if people came to me specifically about issues in relation to the former First Minister, at that point, I would have viewed that as something that should be dealt with through the ongoing police investigation, and that would be for people to consider how they wanted to do that. Clearly, if people came to me about issues that were nothing to do with that, I would have continued in my role as I did do from time to time.
Okay.
Does that answer your question?
It does, yeah. Thank you.
Margaret Mitchell.
Just a couple of points of clarification. You said that Barbara Allison had indicated to you that somebody would want to come forward and engage with you in your confidant role. Can you remember what date Barbara Allison told you that?
So this is where, as I say, it was after the 13th and before the 22nd, because it was Miss A that she did mention to me, wanted to come and speak to me. So it would have been in that short window between it would have been probably towards the end of the week, but I can't be certain, which is why I'm frustrated I don't have the text, because if I had the text with Miss A, I would have been able to tell you exactly, but it was towards the end of the week of the 13th, and perhaps I couldn't say more than that, to be honest. It would be unfair. I couldn't say more
wasn't maybe
specifically.
within the first couple of days of your appointment, you might have remembered that more towards the few.
So I was appointed on the 13th,
yeah.
And Barbara would have spoken to me after that, and as I say, the meeting took place on the 22nd.
Okay. And could you just clarify, you said that from August 2018, the role or your role really hasn't been promoted.
Mm-hmm.
Is it fair to say the Permanent Secretary promoted it initially with her email? And yeah, and it would have been her responsibility to continue to promote that role?
I think it would have been for HR and the PermSec, and I think if you look in my, once you get the papers, there was a note on the 29th of November where I did suggest, which was back in 2017, that it might be helpful to be clear with the organisation that people had come forward and found the role helpful, because it might have encouraged other people who might have issues around sexual harassment to come forward. But the role hasn't been promoted in recent times, and some of that may well be because obviously Laura Dunlop was asked to review matters more generally, so it may be thought that that's something to be looked at in that overall review, and indeed the committee may want to look at that as well in their recommendations.
Yes, certainly when the FDA came, they weren't able to establish, they thought the role was still there, but they weren't very sure, so it was clear that, you know, it wasn't advertised.
Yeah. And I mean, I would obviously have spoken to the trade unions from time to time if I thought that was appropriate. So, yeah.
Okay, thank you for that.
Okay, that's us. Can I thank Ms Russell for her evidence today? Thank you very much. And that concludes the first part of our public evidence session for today. We will reconvene in public session at 3:30 this afternoon, and the meeting is adjourned.